Ladies and gentlemen, today I am going to talk about the history of modern international law during the time period of 11th century to 18th century. In the last episode, I had talked about the early history and roots of international law, and I had talked about the Sumerian civilization, the Greek civilization, the Egyptian civilization, the Roman Empire, and the early Islamic period during the 10th and 11th century. So we'll continue from there and we will start from the 11th century. So, what was happening in the 11th century? During this time period, the organized church was considered as very, very powerful, and nobody had the authority to challenge the authority of organized church. And church had influence in virtually all the affairs of the state. However, from 11th century onwards, the authority of this organized church was beginning to be challenged, as there were constant struggles between religious authorities and rulers of the state. If any one of you have studied history, you must be knowing that during this time period from 11th century till 13th century, many religious crusades took place. So this is a very important event, as it undermined the authority of the church. It lowered the influence of the church in the affairs of the state, and the governance of state started to become more and more scientific. The next event that deserves mention is the introduction of modern printing presses in the early 15th century, that was instrumental in dissemination of knowledge that undermined feudalism and superstition. Because of these printing presses, copies of the books and works were printed, and their authors were able to reach a very wide audience. Due to development of printing presses, religious crusades, and other such events, there was another very big movement that took place in Europe that we know as Renaissance. Renaissance simply means enlightenment, and during this point of time, many new artists, authors, writers, they were able to flourish, and many new scientific developments and artistic developments took place during this point of time. The purpose of telling you all these events is that they formed a precursor to the development of modern international law. Without printing presses, without lowering of the authority of the church in the affairs of the state, it would not have been possible for a just and proper development of modern international law. So let us talk about one of the first treaties in the modern international law. This is the Treaty of Tordesillas that took place in the year 1493 between Isabella I of Castile, Ferdinand II of Aragon, and King John II of Portugal. This treaty established a new boundary or demarcation line between all these states. So this was a very important treaty that we can consider as a part of modern international law. And during the same point of time, that is in the 15th and 16th centuries, development of concept of sovereignty also took place. What is sovereignty, what it means, we'll talk about it in later episodes. But this concept was developed by scholars like Yabudin, Machiavelli, Hobbes, and other such scholars. And because of development of this principle of sovereignty, there was also an increase in the number of independent states. And because of the increase in the number of independent states, there was formation of customary rules of international law. Most of these customary rules of international law involved maintenance of diplomatic relations. So if two new states have been formed, how their diplomats and how their leaders, they would meet each other, how they would transact, how they would conduct their business, all these customary rules were developed during this point of time. And another interesting fact that deserves attention is that before this term, international law, the term that was prevalent was the law of nations. So earlier, international law was also called as the law of nations. The next important event that I want to talk about is the Treaty of Amasya. And this was a treaty establishing peace between the Ottomans and Safavids. A big war took place between the Ottomans and Safavids, and because of this Treaty of Amasya in the year 1555, there was peace in that region. What you also need to know is that the formation of these treaties and customary rules of international law was heavily influenced by natural law. What is natural law? If you want to read more about it, you can read it in the subject of jurisprudence. But crudely speaking, natural law is the higher law, or the law that is based upon the diktats that are passed by the god or by the nature, or law of the reason, or inherent law. These are some of the coterminous terms that are used along with natural law. So natural law played a very important role in the development of international law, especially in the 15th and 16th centuries. And this influence of natural law was promoted by scholars like Vittoria, Belli, Brunus, Suarez, Gentilis. All these scholars, they played an instrumental role in putting the building blocks of modern international law. Now let us come to the 17th century. In the beginning of the 17th century, in the year 1602, Dutch East India Company was formed. And this East India Company was formed with a view to carry out international trade and colonial expansion. Most of you must be knowing that British East India Company was also formed during this time period, and most of these East India companies were meant to carry out colonial expansion in the guise of spreading trade and commerce. However, trade and commerce was extremely important to all these imperial nations because they were very resource hungry. If they wanted to expand their empire, they wanted more and more resources. And if you need more and more resources, you will have to explore more and more territories, you will have to interact with more and more people, and you will have to do more and more business. So, some rules or some laws relating to conduct of business, trade and commerce were also established during this time period. This is known as Lex Mercatoria. Lex Mercatoria is a Latin term that simply means law of the merchants. It was mostly developed in the Britain as Britain was frantically expanding itself and international trade was also increasing at a frantic pace. This discussion would be grossly incomplete if the name of a very important scholar is not mentioned. He is Hugo Grotius, and Hugo Grotius is often called the father of international law. He was present during 16th and 17th centuries, and he wrote two very important works that form the modern basis of international law. These two works are De Jure Belli Apacis in the year 1625, and this work dealt with actual customs that were followed by the states of the day. His another important work was Mare Liberum in the year 1609. This work developed the concept of freedom of seas, and it consolidated all the customary rules and all the customary practices that were followed in the seas, because as you know, seas and oceans were the only means of transportation during that point of time. At that point of time, airways or aeroplanes, they did not exist. The next instance of development of modern international law could be seen in the Peace of Westphalia that took place in the year 1648. Basically, two treaties were signed in the Westphalian cities of Osnabrück and Münster, modern day Germany, and this ended the 30 Years' War that brought peace to the Holy Roman Empire. I am not going into the details of these treaties or the works that I have mentioned, as it would consume a lot of time. Similarly, Peace of Utrecht also took place in the year 1715. Peace of Utrecht is nothing but a series of treaties between Great Britain, France, Portugal and Spain for end of war of the Spanish succession. So you see that more and more international treaties were being entered into by different states. And I am mentioning only few of those treaties. There were other smaller treaties as well that were entered into by different states during this point of time. Like Hugo Grotius, there is another very important scholar that deserves a special mention. He is Emer De Vattel, and he published the famous work of the Law of Nations. As you know that earlier international law was called as the Law of Nations, and this gentleman actually published a book in the name of the Law of Nations. So these are some of the important developments that took place in the development of modern international law. I would like to mention one more event and then I would end this episode. The last event that I want to talk about is the American Declaration of Independence that took place on 4th of July 1776. This Declaration of Independence brought the concept of self-determination to the world stage. Basically, America consisted of many colonies, and these colonies were constantly fighting with each other. But with time, they realized that it's better to have a consolidated government than to fight with each other and be governed by outsiders. So they passed the American Declaration of Independence, which is a very good example of self-determination. Self-determination simply means your right to have your own government, own territory, own culture, own ways of living. We'll be discussing about self-determination in greater detail in the coming episodes. So I'll end this episode here, and in the next episode, we'll talk about development of international law in the 19th and 20th century. I hope you found this episode to be useful. Please feel free to comment or give me suggestions. I would be most grateful for it. And please, please, please do not forget to like and subscribe this channel. Thank you. See you next time.